Okay, so the producers on this show are giving me an opportunity to jump in here real quick because all we're going to be listening to are qualifications of this expert. It's a little bit of a tedious process. There's no question about the fact that she is going to be qualified as an expert in the matter. So it gives me a great opportunity to introduce my awesome guest today, my old friend, Joseph Scott Morgan at Medco legal death investigative person who has been working both in a coroner's office and forensic expert. He's a senior investigator at the medical examiner's office. He's an author. He's a distinguished scholar, practitioner, and professor. Joseph, welcome back to the show.
Thanks for having me, Bob. Good to see you.
Okay, absolutely. And Imran Ansari is a New York-based attorney. He was an assistant district attorney in Kings County, which is a very active county. He's had over 100 prosecutions in cases as serious as robbery, burglary, assault, attempted murder, and has a very large civil rights background. What's the firm that you're working for now?
I'm working with the firm Idala, Bertuna, and Kamins, so criminal defense, but we do a lot of civil litigation also, Bob.
Right, yeah. So that gets back to my old place. You know, if you're a great litigator, you can do it both in a criminal courtroom and you can do it in a civil courtroom. They're a little bit different standards, a little bit different laws. Hey, Joseph, I want to go to you first here. I was surprised in the opening statements when I reviewed them that the defense didn't make a little bit more of a bigger deal that at the time of the shooting or just prior to it, the victim was moving around in an erratic fashion, turned the back towards the officers, had his hands down by his waistband, was in possession of a knife, and interesting, his left hand was down and he spun around very quickly. Immediately, I thought the defense was going to go for the fact that they thought potentially he had another weapon. Would that have been something you would have been looking at when you were investigating a case like this?
Yeah, I mean, at the scene, we would have thoroughly examined this fellow as well as the scene surrounding the body to see if he did have any other means to inflict any kind of harm on the personnel that were at the scene. So, yeah, it's something that I probably would have probed a little bit.
Right, and we had talked about this before. You're a science guy, and as you know, the judge threw out the expert testimony, one of the experts. And Joseph, I've had a big problem with this. We've discussed it. I find that as my 30-year practice has gone on, it used to be kind of hard to get qualified as an expert witness, but it seems like today the courts basically allow people to be qualified. And I was surprised this was all not ferreted out prior to the testimony. What were your thoughts about that testimony?
Well, you know, I got to tell you, Bob, it's hard to know what any particular court is going to do at any particular time when it comes to expert testimony. In many circumstances, I think that either the people that are being represented are not doing a thorough job of bringing forth what the qualifications are, or the opposing side is not truly tasking. I have been seated in a room with attorneys in the past, you know, just talking to them, you know, as we do at medical examiner's office, and they won't have a clue as to what we actually do at the ME's office. And I know that they're involved in other practice, and I'm talking about defense attorneys. So it's kind of a head scratcher, isn't it?
Imran, something that was interesting to me as a lawyer. Do you believe that this could have actually jeopardized the prosecution's case in this way? The defense attorney says they needed that guy. They had to call that guy because they have a weak case. And the judge even threw out his testimony. What are your thoughts?
Well, you know, as you were saying, it really should have been ferreted out prior to calling to this witness to the stand. But as you know, as a trial attorney yourself, once that bell has been rung, the jury has heard that testimony, and although the judge is going to instruct that jury to throw out that testimony, disregard it when they're going to be deliberating at the end of this case, that bell was rung, and it may still have the impact that the prosecution wanted at the end of the day.
Yeah, and that's a great answer, because essentially that is what is told to them. Once the bell is rung, it's very, very difficult to unring that bell. And I do agree with you. I was surprised it wasn't a 104 hearing beforehand to determine the qualifications and admissibility of this testimony. Sloppy, sloppy, sloppy. Hey, you're at the Law&Crime Network. Dan Avens production. We'll be right back. Okay, welcome back. We're in the Van Dyke trial. This is the pathologist that's testifying. Can be a little bit of boring testimony for a prosecutor many times, but they have to show cause and manner of death. Just to give you an answer to the question, the FBI, the enhancement of the video is allowed to come in now through that expert witness, but those arrows that were showing trajectories, the judge disallowed because they didn't have that level of expertise. And I have with me I'm Imran Ansari and Joe Scott Morgan. And guys, I want to get into one matter here that one of our chat room people brought up, Fun Free, and others, about what was this question about whether or not he died at the scene or at the hospital, and does it make a difference? What do you think?
You know, I actually don't think it really makes a difference whether he died at the scene or at the hospital for the purpose of the charges that Van Dyke has brought up on. You have 16 rounds that were fired and hit this individual over the span of, I think, 12.5 seconds, right? So whether he died at the scene, en route to the hospital, or at the hospital, I don't think is of any comport to the actual charges that Van Dyke is facing.
Yeah, and Joseph, what do you think about that from an investigative point of view? I don't see that question having any major relevance myself. I think it was just more of an anecdotal question that went out there. But do you see any significance to it?
Yeah, if you'll let me go a little bit afield here, I think that where it could play into is when it comes to civil litigation. This can go into things, and I've been involved in cases like this, like pain and suffering, that sort of thing. How long did he, quote unquote, languish there on the ground before he passed away? Did they render help in a sufficient amount of time? That sort of thing. It can play in that, but it's from the criminal perspective. I think that you don't have very much at play here.
Yeah, that's, you make a great point, a difference between criminal and civil. That's why I love having you on, Joseph, because, in criminal, I don't think it makes much of a difference at all, but pain and suffering, actually, if you die quicker, you get less under the civil laws. You got to love Law and Crime Network. It is a Dan Ames production, gavel to gavel coverage. I got some great guests. We're going to be back on the other end. Get in that chat room. So, Imran, tell me, when you see these graphic images that are in court, you just can't show graphic images as a prosecutor in order to inflame the passions of the jury, but you can show them if they have evidential value that will assist the jury in coming to a conclusion. What are your thoughts?
Sure. Exactly what you said. If the sole purpose of showing these photographs, the graphic autopsy photographs, is to sort of bolster the prosecution's case, get that emotion going with the jury, the judge should not allow that in. However, the prosecution also has to prove their case, and many times these autopsy photos go directly to what they have to prove, the elements of the crime, the forensics of it all. So there's a balance there, and ultimately the defense would object. The judge would make a determination. So autopsy photos and graphic photos brought in just essentially to get the jury emotional, that's a no-go. But if it has forensic and evidentiary value, that's going to be allowed in.
This is why it's great that on the other end, we're going to have to take a break, but on the other end of that, the producers have promised me we're going to be able to get to Joseph Scott Morgan, who is the man that would know about whether or not the prosecution is doing something to show. I can just tell you from my own anecdotal experience, I had a case one time where a woman was set on fire with gasoline, and the autopsy photos were absolutely horrific. The defense tried like everything to get them excluded. We did believe they had evidential value, but I'm not going to lie. We also know that they had a significant impact on the jury. You find that in cases.
Of course, and also, when you're making the decision as a prosecutor, I'm a former prosecutor, as are you. When you're making that decision to put those photos into evidence, there is the evidentiary value, but you're also thinking in mind, you want to show that jury how heinous this crime was.
Right, exactly. And you got to watch on the other end that you don't do it too much, that you create an appellate issue. So it's a delicate balance for the prosecution, like everything else, not to overwhelm the jury with prejudicial evidence that could impact their decision. Hey, on the other end of the break, we're going to come back with Joseph to talk about whether or not they're scoring points. We'll see you then. With Joseph Scott Morgan. Joseph, you're a board-certified fellow of American Board Medical Legal Death Investigators, which I understand is less than 200 in the entire country. Having worked in a coroner's office in New Orleans, a senior investigator, medical examiner in Atlanta, let me ask you, are you listening to anything here that is overwhelming in terms of proving something in this case, other than maybe inflaming the passions of the jury? Are they doing a good job in presenting it?
Yeah, I think that they reasonably are, Bob. The thing here is that what they're describing is that this is a dynamic situation. Remember, she keeps saying there's no way to determine the order of fire. There's no way to determine if the police officer was superior physically to the victim in an asymmetrical relationship, because it's very dynamic. Now, to your point about the imagery, there is certain of these images, as we're seeing right now, that can go to relationship between the victim and the shooter. I'll give you a great example. She's saying something without saying something. She's talking about the ring abrasion on the injuries, and what that means is that that's a determination of distance. Because there's no powder, you have the ring abrasion that demonstrates that this bullet traveled at some distance, abraded the injury as the bullet's spinning, but there's no powder. That means it's at an indeterminate range in a physical sense. So we can't have hard scientific fact relative to the relationship between the victim and the shooter. This has been a point all along that they have talked about, because you have angle, you have perception, all of these different things come into play. And I think the prosecution is doing a pretty good job here.
All right, excellent. Let's get back into court and listen to some more of this testimony. Okay, a sudden break here at the Law&Crime Network. Dan Abrams production. I love this case, the Jason Van Dyke case, because it is yet again another police officer that's on trial for having killed this man, 16 shots fired. The prosecution and defense openings painted stark and different accounts of what went on here. We're listening to a pathologist testify. It can be a little dry and boring as a homicide prosecutor myself, unless there's some wow evidence that's out there that's going to show how the crime was committed or goes substantially to the proof of murder in the case. You kind of got to do it because it's required to show cause and manner of death beyond a reasonable doubt to the jury. So, Joseph, are you hearing anything else that you heard in this testimony that you think is assisting in explaining why this shooting took place and why so many shots?
You know, I got to tell you, Bob, I was really scratching my head over this. There's one point I want to bring to the floor here so that all of our listeners can be fully aware. The police worked on something that's called escalation of force, and that is, and I know that you're very familiar with this, when you engage with somebody, what steps have you taken? You know, you've addressed them, you've told them, stop what you're doing, cease and desist from what you're doing, and then you meet the threat with a necessary amount of force. Now, one of the things that's been talked about over and over again in this whole narrative that's come forward after all these years, they talk about was there anybody there with a taser? We never really got a good answer to that over a period of time. And, you know, I think certain people are saying, well, this guy might have had mental problems. I think even Rahm Emanuel said that he was going to have the police trained in, you know, interdicting mental health issues. They're trained in that already. This is a dynamic event that is occurring right in front of them. Now, I have to question, why would you shoot 16 times? You know, what was going on at that point? What else is it that we don't know that maybe the police officer knew that was the driving force? Did they suspect that this guy was an imminent threat? But when you look at the image, Bob, there's so much distance between the shooter, who is the police officer, and the victim, who kind of twirls around, falls to the ground, and then they walk up and kick the object out of the way, which I can only assume was the knife.
Right. So, Imran, you know, what we have here is a guy had a knife, supposedly threatened somebody with that knife, now is not following police commands, walking away. But that spin to me is a person who's been trained in firearms training. The guy could have had a gun in his waistband. What are your thoughts, real quick, in 10 seconds? Sorry.
Right. I mean, it's a sort of dynamic circumstance, as Joe was talking about. And, you know, the officer acted quickly. Is whether he acted reasonably under the circumstances, and the jury is going to have to decide that.
And the question will be whether or not 16, 13, 10, 5 really makes a difference when you're supposed to neutralize the threat. We're going to be back on the other end. Okay, welcome back on this Van Dyke trial. It's amazing. Let's go a little bit back to what you were saying, Imran. There's a dynamic scenario going on here. Cops are getting calls that there's a guy with a knife threatening to stab 1 or 2 times a previous person. They argued, at least in opening statements, the defense, that he started to move towards an area where civilians were either at Burger King or Dunkin' Donuts, wasn't following commands, was acting erratically, had a knife in his hand, hit a window of a cop, punctured the car tire of the police officers, acting erratically. And then we talk about, I wish we could put that graphic up, where he's spinning around, he's doing that quick move. And when you're being trained, you just do not know whether or not somebody has, you can see it right now. Take a look at this. He's just not listening to commands. He's not following commands. Cops are out with their weapons drawn. He's starting to move towards the area where they don't want him. And here comes the move. Boom. I mean, I don't know. I mean, a reasonable officer could fear if they were fear of their life, they could have been shot. But I'm surprised the defense didn't bring it up in the opening. Thoughts?
Right. Well, I think the defense will actually hit that home on summation, and as they go to their case, if they put on a case, because that's really going to be the telling piece of testimony or evidence that what was Officer Van Dyke at that moment? What was his perception? So you see that quick spin, and you can argue on the defense side that a reasonable person, a reasonable officer with his training could perceive that move to be something threatening to him, his fellow officers, and that's why he was justified in taking the action of shooting. However, what really goes against that is the fact that there's 16 rounds. So he shoots once, neutralizes the threat, but he goes beyond that. He shoots 16 rounds into this individual. It's sort of the prosecution with that. 16 rounds is going beyond what was needed in that situation.
Okay, well, we have Joseph Scott Morgan with us, and offline, we were talking about that 16-round shot, and what the officers are trained to do is try to hit center mass and neutralize it if they believe that they are in serious risk of death or bodily injury. And I'm not certain I've ever heard any of the training I went through in the firearms course that tells you that 4.2 shots, 7.965 shots, 8 shots, 10 shots. If you believe your life is in danger, the body is moving, it's going down. I'm just saying you can get 16 rounds off pretty quickly. What are your thoughts, Joseph?
Talking about this shooting from the perspective of a civilian or from the perspective of a law enforcement officer, they are held to a different standard here, Bob.
Right.
You know, how many rounds does it take? Well, I don't know. Again, lighting comes into effect here. Positionality comes into effect. And this guy, when you watch him in that, as he's egressing or progressing toward them, he's very defiant. He's upright, erect, you know, kind of strutting down the middle of the street. If he's already attempted to attack someone, this vehicle, this sort of thing, acting very aggressively, the police officers, their adrenaline might be at a real heightened level at that point in time. And even after he drops here in this video, you can see after the shooting is done, you'll still see another round that'll bounce up off the ground there, and dust will fly. And it's a rather telling sign, isn't it? We're looking at this thing. Is he completely down at this point in time? He's still moving there. See that flash that popped up just then? Mm-hmm. You know, it will cause the jury to raise an eyebrow. What was your need? What were you trying to accomplish here?
Yeah, and you know, the jury, the defense, I'm sure, is going to bring, they alluded to there in the opening statements, expert testimony. It's going to talk about the tunnel vision of officers, despite all the training you can have, how fast it takes a brain to process what's happening. I've literally been on scenes, and moreover in training, where they actually have the shooting going on, and somebody's standing behind the cop or another person with guns to the cop's head, and the cop was so focused on the shooting, he didn't even realize 2 people were next to him with a gun. It's not an easy scenario. Of course, it doesn't justify killing anyone, but, you know, let's go back to a real basic point before we flip to another part of the Law&Crime Network. This is why I love this network. I have to say, this is what happens when you're in a police encounter and you are not following instructions. It turns out that, at least as a proof in this case, it's going to be he potentially was on PCP. The cops are told that he's trying to stab somebody. He's not following police commands. He hits a police vehicle. He stabs a tire. He's not listening to commands, walking down the street with a knife. And that move where his hand is by his waistband and he spins around, why was he spinning around? That's what I'd be asking as a defense lawyer. Why was he spinning around? It almost seems like, if you ask me, guys, I know it sounds crazy, a little bit like what somebody with suicide by cop would want to do. I'm sorry, That's just how I see it.
Right. No, I mean, if you're defense counsel in this case, you're really taking all those points that you just hit, Bob. You're stacking them up, and you're putting that before the jury. You're saying, listen, this is the situation that was drawn out, which was unfolding before this officer's eyes. This was what he felt was reasonable in that circumstance with his training. And you take all these points, you put that in perspective from the defense side, and that's why you say this was justified.
And like Joseph Scott Morgan was indicating, the law with respect to the officers and their ability to use of force, even lethal force, is much different. I'm going to get into that on the other end because there's some really fascinating law that the defense attorney brought out. And guys, remember, no matter what your feelings are about the case, it's about what the law says the cops are able to do. And I thought the defense did a very effective job at explaining when an officer is allowed to use lethal force. I have two awesome guests. We are going to get back to that piece, but we got my favorite top crime stories. Let's get to it.
Here are today's top crime stories trending on Law&Crime.com and across the country. Wanda Barzey, the woman convicted for helping former street preacher Brian Mitchell kidnap Elizabeth Smart, will be released today. Barzey was arrested in 2003 and pleaded guilty to second-degree felony aggravated kidnapping and sentenced to 1 to 15 years in prison in 2010. At the time of her conviction, she was not allowed a credit for time served toward her sentence, but her attorney was able to get that decision reversed. Elizabeth Smart released a statement slamming the decision as disappointing and incomprehensible. Smart was reportedly told a federal agent will keep a close eye on Barzey. Barzey will be under federal supervision for the next 5 years. Investigators in New York City released video of the harrowing moments when a deli worker in the Bronx wrestled a gun away from a would-be robber. The robber can be seen striking the clerk in the head before losing his weapon and fleeing the store. The clerk suffered minor injuries and the suspect remains at large. Authorities released video footage of the moment a K-9 officer took down a man trying to kidnap a child. 24-year-old Kevin Wilson allegedly tried to kidnap a child in Newport Richey, Florida, before being engaged by Pasco County K-9 officer Titan.
Roll over or we're not taking the dog off. Good boy. That's a good boy. You hold that man.
Wilson now faces charges including interference with custody and child neglect. Those were today's top crime stories. I'm Anthony Velez for Law.
They're pretty amazing guys, and this is a regular guest, appearing guest on Live PD. You know, Dan Abrams is hosting that show, which is off the hook, not only in what it's showing in terms of its ratings as well. You know, my experience has been a little bit different. I remember one time we were looking for a suspect in a murder case, and those dogs were looking and looking and looking, and to our embarrassment, believe it or not, the guy was only 15, 20 yards from the command post, and we only found him when somebody went to go to the bathroom because there wasn't a potty. But this dude, he's knocking it out of the park. Joseph, do you ever have experience with these dogs?
Yeah, I have. I've been terrified by them, as a matter of fact. And I have a lot of respect for the animals as well as for their handlers. And all you kids at home, keep your hands away from their mouths, whatever you do. They are highly effective, and the police officers view them as officers, and that's the way they're referred to as. So you have to treat them with quite a bit of respect.
Well, I'll tell you what, under the law of the state of New Jersey, if you attack a police dog or kill a police dog, you have essentially killed or attacked a police officer. Have you ever had a hand on one of those cases?
Well, you know what? I had the opportunity of actually watching the NYPD train their K-9 unit one day through a detective pal of mine from when I was in the DA's office, and it's just fascinating. And, you know, the bond between the officer and their K-9, it's amazing. It's their partner.
I want to interrupt you right there. The most riveting trial I've ever seen, I wasn't trying, is being in a courtroom with a cop who got beat and his dog got beat. He was as tough as nails, this cop, as he was talking about getting hit with tire irons and bats. But when it got to the dog, he literally choked up and cried, turned to the defendant and was crying hysterically. You didn't have to hit the dog. The dog wasn't attacking you. It was riveting. I get goosebumps every time I think about it, and that was many years ago. Hey, Law&Crime Network, Dan Evans production. We are going to a break. We're going to come back on the other end. Great case, great guest. We're listening to the pathologist in the Jason Van Dyke case, Joseph Scott Morgan, with all of your background, working in the ME's office, having been in court, testifying, professor, written materials. I get it. They're showing each and every wound that he had. Are they making any points on what the ultimate conclusion to this jury will be as to whether it was a justified shooting or not?
That's a curious question, particularly considering that she cannot tell us in what order these were fired, which is almost impossible to do, because if we knew the order, we would know the level of lethality, if you will. Say the number one shot went through the chest and clipped a vital organ or clipped a vessel, but we don't know that. What they're showing and demonstrating here is that there are a number of insults to this fellow's body, and you just don't have 16 rounds that have struck him. You've got multiple other holes that have been created relative to exit wounds, and also you've got rounds that are breaking apart. You see some of the x-rays there where you've got this kind of lead storm that's in there where both bone and the bullet have fragmented, and this creates other injuries. She's talking about pulpifaction and all these things. So I think right now they're really hammering home this graphic nature of what happened to this victim in the middle of that street.
Yeah, Imran, do you agree that I don't know with me that I don't know, I'm just saying stylistically, unless these wounds are going to be able to tell you the mechanism of the actual death or when it happened or how it happened or how many bullets afterwards he was already dead, I get it, but you can keep emphasizing that 16 shots over and over and over and over again, but are you getting to the meat of the matter, which is meeting the legal definition under the law that will be read to the jury that will tell them that this was an improper use of police force?
I mean, at this point, I think the prosecution is really just going through the motions, so to say. I mean, they have to present that forensic evidence to the jury. They have to show the manner of death. They have to bring in the ME and bring that autopsy report and the findings before that jury. Whether it goes to the question at the end of the day before the jury, I think it could be argued by the prosecution that you see all these entry wounds, exit wounds, all these gunshot wounds, and you bring all the photographs that was brought into evidence through this ME examiner, and then you point out to the jury, look at the level and intensity of this crime, of this shooting. This wasn't just one shot, this was 16 shots, and you hammered that home.
Absolutely. Okay, listen, Law&Crime Network, we're going to go to a break. We'll be back on the other end. Okay, guys, we're going to take a little break here because we're just listening to the same testimony. Here's the entry wound. Here's the exit wound. I don't believe it's leading to anything significant. My producers will let me know if there is in terms of resolution of this particular issue. It's what a prosecutor needs to do in order to make things happen. Now, I'm sorry if I don't get this right. One of our chat people, and I love your questions out there. They're really good. Busted, I'm sorry if I got that wrong. You asked a really important question here about what does a cop have to be in fear of his life to shoot if they're not in danger, essentially. Guys, I want to talk to both of you, both of my guests. This is what was said in the opening statement. I'm not saying it's the law, it's what they said. The police officer has no duty to retreat in Illinois. Deadly force when there's a reasonable belief to protect themselves or others from serious bodily injury or deadly force. That's a second basis. Deadly force to prevent an escape of a violent or forcible felony that was committed. Remember that stabbing potential before. Escape by an individual with a deadly weapon. Great bodily harm unless arrested without delay. This was them talking about going to the Burger King or the Dunkin' Donuts. And, of course, he brings up it's their job to affirmative duty to protect the public. We've seen the overall case here. There's lots of bases in which a police officer can use deadly force that are beyond just feeling that their lives or others are at risk for serious death or bodily injury. Give me 30 seconds or less. What do you think that leads to us here?
Sure. I mean, the defense is essentially going to be setting the stage to check off a number of those boxes, which they can then argue that Officer Van Dyke did have that subjective, reasonable belief that led him to use that force and that it was justified. They're going to check those boxes off.
Yeah, excellent. I mean, I thought the defense was very powerful when they brought that out, if in fact that's what the judge ultimately charges the law to be, but I'm sure the defense had it pretty squared away. They wouldn't have said it. Joseph Scott Morgan, my friend, what do you think about what the defense said in terms of all the multiple ways that officers are justified to use deadly force?
Dynamic situation. His colleagues are in danger. They're fearful that this guy might run over to a local restaurant. He's already fled. He's failing to follow commands. He's in possession of what they believe is a deadly weapon. This has already been evidenced by him stabbing the tire on the vehicle. the question goes to, did this officer feel as though that all of these things were creating a perfect storm where somebody could have sustained grievous bodily harm and he needed to neutralize the threat?
Right, and failure to listen, and also the previous incident where they got called on a knife threat where attempted to allegedly stab a person 2 times. Joseph Scott Morgan, I got to move so quick. Watch me do this. At Medical Legal Death, distinguished scholar, coroner's office, medical examiner's office, good friend, excellent witness, and Imran Ansari, my first time with you, Assistant District Attorney, Kings County, over 100 prosecutions, working at the Adala law firm. You're awesome as well. We'll be back on the other end of the break.